All right, good afternoon and good morning, everyone. Thank you again. As mentioned earlier, I'm Michael Corcione, Managing Director of Cordium Cybersecurity and Data Protection Division. I want to thank you for joining our webinar today on Cordium's Insights on GDPR and what you need to know. Definitely a hot topic out there with 37 days left to go before the May 25th deadline and implementation requirements. What we'll do on today's webinar is we're going to have about 45 minutes of content. We'll have 15 minutes at the end that we'll do some questions and answers. I also do want to call out to our attendees to notice there is the ability to submit questions throughout the presentation, and we'll be glad to try to pepper those in through the dialogue as well as answer as many as we can at the end. I want to thank and join my colleague today, coming on board with me, Robert Baugh, CEO of AmberGate. Good afternoon, Robert.
Good afternoon. Thank you very much.
Great. And so Robert and I have done quite a bit of work recently helping clients with GDPR, really since the middle of last year. Robert, I know you have a strong background in the data privacy experience space. Just a little bit on your background to fill in the attendees.
Absolutely. So I founded AmberGate last year, and prior to that I was general counsel of VC-backed growth tech companies for about 13 years or so, dealing very much with IP-based and data protection, privacy-based companies where the security and data protection was key internationally.
Great. Thanks, Robert. And so Robert and myself have been having quite a few conversations with clients, getting a lot of feedback. Robert, I like to say when I ask people, what have they done with GDPR so far? I've heard a lot of confessions.
Yes.
A lot of people at different stages of the game. Obviously, a lot of firms have different levels of risk when it comes to GDPR, and so it's really a matter, are you doing what you need to in regards to your organization? So what we're hoping to do today with the time that you've allowed us to share with you is give some insights on GDPR. We are going to try to focus specifically on some areas that we know are higher risk with the majority of our clientele and firms across the industry space. We'll have some polling questions during the session. The first one we'll bring up now, which actually comes into where we have some clients have expressed delays in certain parts of GDPR. And so the question comes up, is GDPR compliance causing delays in sales or revenue growth? And to answer this question probably a little bit further where we see it with some of our investment management clients is, are you getting those due diligence requests from investors, or investors slowing the process of making commitments or customers or orders based on GDPR requirements? Or the question coming from the investor, are you GDPR ready, or are your contracts and agreements GDPR compliant? So we'll give a couple more minutes here, actually I should say a few more seconds here, and we'll let the votes come in. We're seeing probably about 50%, some varying scores coming across the board, and we'll allow the time to capture them. It's definitely skewing one direction or another, but I think what we can do to my marketing team here is we'll pop up the results and see where we are now. Okay. So across the board, we actually had 87% say no, they are not seeing this pressure. 13% have said yes. I think this definitely folds into what type of business, what type of space you're in. In the fund management space, we have a client that's getting ready to launch May 1st. During the last 6 months of that fundraising area, they've seen quite a bit of pressure coming from investors. I think in some cases they might not realize what the requirements are on their side yet, or what's going to be needed to put in place. Robert, I know we've seen some of the pressure here with the contract side, and even some of the contracts and clients that we've spoken to aren't necessarily even familiar with what's needed to be done.
That's right. I mean, you can actually see it was quite interesting as the votes came in there. It started off with the majority were no. It was like 95% no, and then as the number of people voting went up, the yeses climbed. So we had 66% voted. So maybe if, with a higher vote, might have got a higher on the yes part. We've had certainly some customers in the IT space, in particular, contact us saying that they need to have a good answer on the GDPR before some customers will sign up with them. This is a Cisco survey that came through on the privacy maturity benchmark. 65% of businesses experiencing sales delays due to privacy concerns. This was an international study. It's a great study. I recommend looking at it. The average sales delay, 8 weeks, interestingly longer in the UK. And also, this is very much linked to your privacy maturity. So the more privacy mature you are, the more you have policies and procedures, we'll come on to that later on, the more you've trained people in that, the shorter the delay, the more ad hoc you are, the longer the delay, to an eye-watering 16 weeks for the worst. And interestingly, it also correlates into your risk of a breach, which would cost over $500,000. So the privacy maturity part, we have seen that qualitatively in the Cisco survey, suggests quantitatively, and 13% today have said that they have experience on that.
Yeah, and Robert, as you mentioned, we'll definitely talk more about maturity as we get through the path, because that's a word and a term regulators really look to measure firms on how they're gauging their compliance. So coming into our next slide, we've put together this as really a high-level overview of the GDPR principal areas. We've highlighted the ones that we've had the biggest concentration of risk with our clients, where investors, where they need to put some focus. The governance, accountability, and records of processing really fall into a lot of those responsibility areas. Some governance that needs to be put in place. Documentation. There's policies and procedures that we'll talk a little bit more further in the presentation that haven't been required in the past. Coming across on the vendor due diligence and the requirements there. So these are one of the elements of GDPR that really firms should have been doing all along, but another layer has been added in regards to what you need to do with the vendors, as well as incident response, better definition of what needs to be reported, and of course the timing around the reports. Robert, you've been through all these areas and domains before it was called GDPR, but now the regulation has moved to fines and penalties, put more focus here.
That's right, and as you say, so GDPR, I tend to think of it as partly, maybe half sort of reinforcing the current regime and half introducing some new aspects, as you say, very much around the use of processors and also data subject rights and the notifications. So the record of processing in the middle there is really key to a lot of it. If you don't have a record of the personal data that you're processing, you don't know what obligations you have, what processes and procedures you need. If there's a breach, you don't know how much has been affected. If someone asks, let's use a data subject request, you don't necessarily know how to where to go to respond to it. So that record of processing is a fundamental block to all of these three areas that we're going to touch on today.
Great. So come in and talk more about governance. I think, in looking at some of the attendees that have joined not only this webinar today, but, the half dozen breakfasts we've had over the last 6 months that have also been very well attended. We see a lot of people from different parts of the organization showing up. Most often it's compliance. This is a regulation, definitely an area where compliance folds into the mix. And so what does it mean when you're adding more around GDPR? As most people know, in compliance area, a lot of it's policies and procedures. But, primarily you have to start with, the roles and the responsibilities. Get an understanding of what needs to be done, who's going to do it. If you're going to engage on any type of project in an organization, you need to have senior sponsorship. What helps in those areas is really pointing out to senior sponsorship, what's the risk, and understanding what's the impact on our business. Part of the regulation talks about a data protection officer, and we'll talk a little bit about that because I know there's some confusion as to not only what is the role of a data protection officer, but do we need one, and is it required to be in space? And next bullet coming down, data subject rights. Robert, this is really where the biggest changes come around GDPR, or in GDPR out of the data directive. Right?
It really has, and it's the new rights of porting your data, the codification of the right to erasure, the right to be forgotten that came out of the Google case in Spain. And that's where the records of where your personal data are and the policies and procedures about how you respond to one of those is going to be interesting. I think also the individuals now know that they've got a lot more data subject rights. Obviously the recent Facebook scandal, Cambridge Analytica, there's a lot of people looking to exercise their data subject rights. A lot of people have been to Facebook and downloaded, what personal data do you have on me? So I think data subject rights, depending on the industry you're in, obviously I think the financial services sector is going to probably have fewer receipts of data subject rights requests, but something more like a retail operation would have more. I know that some major retailers are looking to see a large uptick in the number of data subject rights requests. On the data protection officer bit, this is part of the roles and responsibilities, as Mike was saying. So the senior sponsorship is really key for the project to have a chance of success. But what's a data protection officer? Well, A data protection officer, you don't really want to use that title unless the person is going to have that role. A data protection officer is a statutory title under the GDPR. Anybody can designate a data protection officer, but the people who have to, public authorities or bodies, apart from courts, if your core activities is processing regularly and systematically monitoring data subjects on a large scale, or if you're processing on a large scale the sensitive personal data, which is now called special categories of personal data or crime data. So if you fall into one of those three main buckets, you need to appoint a data protection officer. If you don't, then think carefully about it, because in terms of using that name, the title, and maybe call them a privacy officer, but you'd still want someone fulfilling those functions of helping you internally.
And when looking at the data subject rights that we'll talk about a couple slides later, that's an area where does my technology team need to be involved? And so in a lot of areas around compliance these days, it's a team effort across the organization, which leads into the topic around training. And so ultimately, you need to train all your personnel. There's going to be some aspects of procedures and data handling that need to be adjusted, i.e. we don't capture this type of information anymore, or when we capture it, we're going to store it in only these repositories, because managing the life cycle, the retention, and the end of life of the data is ultimately critical under GDPR. And so talking it actually just with a client this morning, Robert, we were going over training and, what is the right approach on training? And there's a few various stages. Why don't you share a little feedback of kind of how we went through with clients, because the deadline is coming up pretty quickly, and you probably want to do something on that aspect before that deadline.
Absolutely. So on the training, the usual way that we recommend it, you can obviously get more sophisticated, but we recommend splitting your personnel into three levels. So you have level one would be your general employee, contractors, etc., who need to know about the data protection aspects, and you would run a general training process on the what is the GDPR, what does it actually mean, what does it mean for the business, why should we be worried about it, what are the main risks, what's my place within the governance structure, where do I go to find out more information in particular aspects. So if I get a data subject right request, what do I need to do? If there's a breach, what do I need to do? So you give everybody a core level of training in the data protection governance. Then level two would be people who would need a certain extra level. So they might be the people who are going to be running some of the policies in different departments on notification or responding to the rights. And then you'd have level three, which would be your privacy officer and the senior sponsor as well, where they would have training across everything. As I say, you would tailor it as appropriate to that role, and also when people move roles. But you want to get a baseline level of training in for everybody before the 25th of May. Just get a record of that they've all had that level of training.
Yeah, absolutely. And so coming into the next section down here on the bullet, which really tails into our next slide, is maintaining audits and records. And so one of the aspects that comes into GDPR is records of processing. And personal data, as we mentioned before, is the main focus. And Robert, you mentioned Facebook before, and we didn't use the company name specifically in client conversations before the break of the Cambridge Analytica story. But really, that's a big focus of what GDPR is zoned in on is, what is somebody else doing with my data, my rights to my data. And so what organizations now are going to have to do to be able to respond to these data subject rights is understand where the data is in the organization. At a high level, I like to say where it lives, breathes, and who touches it.
Yep.
It's a little more complex. The phrase out there, a lot of people hear is data mapping.
Yep.
And so what does data mapping mean? Are we drawing pictures? Are we using technology? Ultimately, you need to start with some foundational record, which usually starts at a spreadsheet level, and then at some point evolves into a software tool. But Robert, we go through and we ask those critical questions tied to what the regulators are looking for. If you could give a little bit to our listeners in today more about what the specific Article 30 records is,
yep,
and why the regulators are looking for, and maybe just a high level some of the content around those questions.
Sure. So the data lifecycle, as we've got it there from collection through to end of life, you really want to go through, this is a foundational part, as you say, of any compliance project. So you know what personal data you collect, what information have you provided to people, what categories of personal data are you collecting, who from. Those are things that go into the Article 30 records. Who do you share it with? You'd want a more detailed list as you go through in your own project, but the Article 30 records want to see categories of recipients. You would use your more detailed list to do a risk managed approach to address your processing agreements with them to bring in GDPR compliant clauses. We'll talk about that a bit later on with the vendors. Whereas it's stored and secured, and the Article 30 records want a high level description of your security processes. Do you transfer it? By transfer, we mean outside Europe. So do you transfer it to the US, for example, very common? And what's the basis for that? The privacy shield. How long do you retain it? Do you have a retention policy? This is one that often we find with clients. It's one of the things I haven't really looked at too much. And then what happens at the end of that retention policy for end of lifing? The Article 30 records essentially replace the notification with the authority. So under the current rules, you have to notify with the Data Protection Authority. Under the GDPR, that notification goes. And these Article 30 records essentially replace that public notification with a private register that you hold with that sort of high-level data about what you're doing. But you can't create that unless you've done the iceberg below it of what data do you have.
And so that leads to one of the questions that one of our listeners just chimed in. Really, what is meant by personal data? And the question goes further. If I have contact information, which is a business email address and phone numbers, is that classified as personal data? So we get this question probably at the beginning of every dialogue with clients. Robert, you want to fill in a little bit further? Because it is somewhat confusing.
It is a bit confusing. So personal data, though, is anything that identifies an individual or can identify an individual directly or indirectly. So our work email addresses and our work landline numbers, they are personal data about us because they can identify us. Just the same as our private personal email address or our private postal address. The difference really between those comes when you look at marketing and the rules around marketing B2C, business to consumer, and marketing B2B, business to business. So anything from which a living individual can be identified directly or indirectly as personal data, and that includes identifiers such as IP addresses can be, if they're static, or if they're dynamic and you have the other information that you can actually identify who that is. It could be in the GDPR has called out specifically genetic data and biometric data, which is in the special category of data. But really any data that can identify a living individual directly or indirectly as personal data, whether it's business information or not.
Okay. Great. And so we have another question coming in, which I think is going to tie right into our next polling question. The question from the caller is there a standard, are we required to have a written document of GDPR policies? And the answer is absolutely yes. And so in the rules of the eyes of a regulator, if it's not documented in a policy, you're not doing it. If the procedure's not documented, you're not doing it. And unfortunately, there are many firms that I've seen in the past in other regulatory areas where they were doing good things and got penalized just because they didn't have it documented. So it's a shame to not get credit things you're doing. Where the next polling question comes up and asks the response around, do you have practices and procedures in place to respond to exercise of data subject rights, including erasure? So I'll ask our attendees if you can start chiming in as I go through a little bit further in response to the question and chime in with Robert a little bit. There's a multitude of policies and procedures.
There are, and for example, if just to see some sort of independent proof, as it were, if you go to the UK Information Commissioner's website, you'll see they give a guide to what happens when they do an audit of a business. And they give a guide to their general audit, and they also give a guide to a security audit. And you can see in each of those the sort of proof that they're looking for, and it is very much a paper-based process at the beginning. They look for your policies and procedures, and they're quite broad-ranging. And the GDPR itself actually imposes an obligation to maintain a governance system that enables you not only to be compliant with the GDPR, but to prove compliance to the GDPR as well. And that is very much also policy-based.
Okay, great. We'll go to the polling results now. And it looks like it's split, 2/3 to 1/3. 67% of the people said no, 33% yes. So definitely some work to be done on the policies and procedures. Data subject rights, of course, is an area that is new. And so that's not a surprising number. To be honest, I thought it might have been a little bit higher based on what we've seen a few months ago. So firms are making progress We had a couple other questions coming in around templates for policies and procedures. We'll get into that a little bit further down the conversation. We did have just a circle back and a little more clarity on that personal data and the business email address.
Yep.
And if it's something that can lead to the identity of an individual, then it falls into scope.
That's right.
Yep. Okay. So that being said, we'll slip over to our next slide, which is talking more about accountability. And so being able to demonstrate how you comply with GDPR, this really ties into the question the individual just asked. Strategic proof is what the regulators will call it. Do you have the policies and procedures? Tactical proof is really showing the testing against the procedures. And we have a slide we'll get into a little coming up next that'll go through more of the maturity. But think about it, any control that you have in place, it needs to be reviewed. It needs to be evaluated for its efficiency and effectiveness. Otherwise, how do you know it's functioning correctly? And so proving compliance to regulators to show that you've not only identified high-risk areas in the firm, you've put in appropriate controls, you've trained your staff, you need to evaluate the controls to make sure that they are working and that they're functional. We talk often a lot, too, about the cyber and information security being the foundation, because the phrase comes across as you can have security without privacy, but not privacy without security. So it is the foundation. These are the controls that have to be in place, and it's a wide range of what can be implemented in the controls in the sense that you're fortunate the regulators let you use a risk-based approach. And what that means is identifying your risk and then putting in an appropriate level of controls based on the firm's risk appetite and resources. And so, Robert, I always, look when the cyber and information security are out, it's really less than 20% of what needs to be done. You get a lot of these organizations sending out technical from sellers. We have a technical tool that'll make you GDPR compliant, but it's really a multitude of tools. And so some people get confused on the technology versus the policies and procedures and the right blend.
But yes, and you're absolutely right in terms of you can't have privacy without security, but you can have security without privacy. So there's a large part of it, as you say, about 19-20% of the GDPR is about security. But security, when you look at the policy of data minimization, only collecting what you need to, keeping it for only the period that it's necessary for, no longer, that's not about security. Obviously, security measures come in terms of how you store it, how you secure it. But because most data now is digital, cyber and information security policy is foundational in one respect in particular, which is managing your risk. So if you look at where your risks are, we've talked about regulator risk. They'll look to see your policies and procedures and your audits and records. They'll also look to see, well, if you have a breach, have you got good security practices in place? If you have good information security practices in place, you're going to be going a long way towards managing that risk. For your customers, where your customers are asking you for proof about GDPR compliance before they'll do business with you, you can show them the strategic proof. Maybe show them that you've got tactical proof, but not actually show them the actual contents, because that's going to be more confidential. And so this sort of comes down to a rounded, holistic approach, risk-based, but being able to prove compliance to those different stakeholders that are asking you to prove it to them.
And so talking about stakeholders and ask that who wants you to prove it to them, we talked up front about the customer pressure. Let's go into the next poll question, which is where there may be pressures coming from other areas. And so we have the same task as investors, customers coming up front, but those that said no to that showing pressure, are you seeing it from any regulators, shareholders, so client feedback, or internal governance, meaning leadership, meaning others within the organization that are coming back and asking, are we compliant? Do we have the right levels in place? So we'll wait a minute here for some of the poll responses to come in. I think they are in line with what we would have expected on quite a few of these here.
Yeah, they time with the previous question and also some of the feedback we've been having. We'll let that go a bit. It's above 55% voted now. If we just let it go that a bit higher.
Yeah, we'll leave it open for another minute. While we're leaving that open a minute, why don't I go to one of the questions that's coming in, actually, Robert? We talked about, data mapping. And,
yes, what is it?
What is it? The question is more specifically on software tools. So not going to look to make any specific recommendations on software tools, but I think what they're kind of inquiring here is, if there is a tool out there, and we mentioned something around technologies, right, like sniffers and finding data, thoughts just on the use of those in the industry, because it's really an evolving space, and I think they require a lot of fine tuning and manpower.
I think that's
not
right.
as simple as people think.
And I think one of the things is you've got to keep your eye on the end rather than the means. So, we talk about this a lot with our clients in terms of where are you looking to get to. So, for example, you might have a mapping tool. If there is a breach, or if a data subject asks for their data, is that tool actually going to help you identify the extent of that breach, what data's been compromised, how far it goes, which parties? If someone asks for access or to delete their data, do you know the recipients of that data? Is that going to come out from the tool? So some tools are doing visuals to varying degrees. Some tools, as you say, are sniffers that go out into your network and look for data and categorize it. You do definitely have to look at the automated processing they're doing to look at categorizing the data so that you have a good understanding of what they're actually capturing. I think really what people are looking at, you can either do it on a system basis, or you can do it on a sort of process basis. You do it on a fully automated basis or on a more of a human basis. And I think where I hear a lot in the industry, and I think is right, is you try and really choose the blend that really suits you and your business and what you need to do with the results, and then choose the tools that are right for you with your network. You can't. I don't think any one on its own will deliver everything you need it to do.
And partly this crosses into the conversation around data classification and how you're managing the data. I think when it comes to the challenges on GDPR, a way to look at it is, my historical data, and what do we need to do to life cycle that out of the environment? Do we have good clarity in that data? How much clarity do we want to get? How much can we clean up? People have gone for years, decades, using storage as cheap mindset, let's save everything. Well, now the more you store, the more liability you have, the more risk you have. So those days are over.
Yeah, we're seeing people cleanse their databases and reducing it by 70%. Is a common stat we're hearing.
Yep.
And a lot of people, when they look at the data, go, actually, how much have we actually accessed that data? How often do we access data that's over a year old, over 2 years old? How often do we access the favorite sports club data? Do we really need that?
Exactly. And another area for IT to collaborate with the business. Don't just tell IT to clean things up. The business helps. And then, of course, going after May 25th, post May 25th, that's where the training comes in and the awareness, and making sure that employees are implementing those new handling procedures beyond May 25th, a blend of classification tools. So we'll come in now, we'll pull up the poll results that we just went through. Looks like 48% getting the pressure from internal governance. That's usually the lead. 38% from regulators. Definitely with the size of fines and penalties tied to GDPR, we could understand that. 13% investors and customers ties into really the number we had up front. And then 1% on the shareholder side. I think that 1% on the shareholder side would be probably a higher number in areas where there are boards and publicly traded companies. Knowing we've done some of those presentations, and at the board level, this is one of the highest concerns and risk areas.
Yeah, it's quite interesting. The internal governance bit actually often feeds through into that vendor due diligence, because part of your internal governance, you're doing it, you end up putting it into the customer due diligence. I'm certainly seeing that come out more and more.
Yeah, exactly. So we'll hop on to our next slide, which we mentioned earlier. We talk a little bit more about the privacy maturity level and what the view is of the regulators when they come in and analyze your environment, your compliance program, and they will rate you based on, are you doing things ad hoc, which means no formality. Repeatable means you have policies and procedures, they exist, they cover all the specific areas, defined, they are fully documented and implemented. Manages this part we talked about before, the testing. Reviews are conducted to assess the effectiveness. So access right controls. If there are joiners, movers, leavers, that process needs to be reviewed. If somebody leaves the organization, what is the offboarding process? Who's connected in? Are they removed from all systems? Not only systems that you have access to or your network, but third-party systems. And so if you offboard somebody, did they have a username and access to your fund administrator site, to your bank account sites, to your CRM site, all things that may not be part of Active Directory that you can easily offboard them. So a really crisp process around your procedures and the testing of them is very, very critical.
A client said the other day that they'd received a call from the bank as an authorized signatory of an account for a company they left 2 years before, which is obviously quite a risk that they're running there. So on this maturity model, this is the American and Canadian accountants privacy maturity model, which Cisco has adopted for their benchmark study. It's that same study we were talking about earlier. And when you look at that, you see that once you get to defined, which is where you have procedures and policies fully documented, and they do cover all relevant aspects. Just having those in place does deliver the significant part of the maturity benefit. So if you go from ad hoc to optimized, by the time you get to defined, you're giving yourself most of the achievable benefit. So then manage to say you audit those, and then optimize, you have a feedback loop to refine them going forwards. But it's quite an interesting result from their study.
Okay, so now going to our next topic that we mentioned before is the data breach. One of the items that has traditionally been around, there's been breach reporting requirements, but now they're a lot more stringent. 72 hours, pretty short time. One of the things we talked about with policies and procedures is an incident response procedure. So how do you react? Having that documented beforehand and define what is a breach is very important. Last thing you want to do at the time of an incident is be making those decisions. If a regulator came in afterwards and asked, how did you gauge that decision? You need to have a document to refer back to. You don't want to say we were making it up as we went along. And understanding what is a breach, what actually is reportable. And Robert, this is an area where we've seen some confusion in the space.
Absolutely. So, for example, just the accidental loss of data could be a personal data breach. And obviously, people will be familiar for quite some time from the information security side with the security breach. So it's a bit like the security aspect. With every personal data breach will have had its roots in a security breach, but not all security breaches will be about personal data. They might be about corporate data, or no data might have been compromised in it, but it could still be a security breach. But where you have a security breach and personal data is involved, it's a personal data breach. Whether that's an accidental loss of data, whether it's unauthorized access to some data, that's something that's often misunderstood, and it comes down to, we'll talk about it a bit more on the next slide, but the typical triumvirate of confidentiality, integrity, and availability, and then you have different measures to address each of those to try and keep your business continuity going. But on this, the rapid incident response, it really is under the current regime of the Data Protection Directive and then the Data Protection Act here in the UK, there is no obligation to notify a data breach to the authorities or to the individuals in data protection law, unless you're a provider of a public electronic communication service, in which case it's under the e-privacy directive and the UK implementation of the e-privacy regs. But if you don't fall into that, if you're not in the electronic communication services business, currently there's no notification obligation. So it's going to be a very big impact that on 25th of May, there's going to be a notification obligation within 72 hours to the regulator if there's likely to be any risk to the rights and freedoms of individuals. So it's a bit of a tier. If you have a personal data breach and there is no risk, maybe the information was encrypted and your keys weren't compromised, you have copies of the data, then you can carry on. If there's likely to be any risk, you need to notify the UK ICO within 72 hours. Again, we'll talk about this with vendors as well, but this is one of those aspects where you're deemed to become aware once your processor is aware. So you want a good contract with your processor, and you want to be sure they've got the procedures to be able to notify you. And then when you have a likely high risk to the data subject, then you actually need to notify the data subject, the individuals concerned. And actually the UK ICO might tell you that you need to, might disagree with your rating and tell you have to notify the data subjects when you didn't initially think so. There are some nuances to it around you don't notify if you're going to be involving the police, for example. It would affect a criminal investigation. You liaise with the authorities. This is going to be something I think that is going to cause quite a lot of confusion, quite a lot of resource allocation. Regulators aren't highly funded and highly resourced. They're going to get swamped with notifications because businesses will take a risk view of, well, I'm just going to notify this. So it'll be interesting to see how these come through. We've got there the processor agreements, insurance coverage. We mentioned this. Mike, you've dealt with a lot of clients with the cybersecurity insurance, but now with data protection as well, where there's an incident response part to it.
Yeah, absolutely. And, the insurance companies, cyber insurance isn't the biggest seller in the space. A lot of people don't actually understand what it is. And in the investment management space, where you don't have a high number of individuals that would require monitoring if there's a breach, it seems maybe it's not as applicable. But if you get the right insurance policy, it will also have coverage in there for incident response services such as forensic teams, other training and support. And so if you do have insurance, you absolutely want to understand fully what they have available and make sure that you are in line with what they are requiring if they do have certain procedures if a breach is reported, so that they are tapped in timely. Ultimately, you have to have a plan. Part of the plan, you want to have a communications team, part of not only the authorities to report to, but even reporting out to investors and understanding who in your organization is going to be part of that decision-making process. So coming into our next slide, talking a little bit more about the personal data breach and what happens in part of your plan. There are some things on the technical side down on the bottom that can really help. Robert, I know you love encryption.
I do.
And use it often, as I like your phrase, can be a get out of jail free card.
Yeah.
And so maybe share a few insights on clients in regards to encryption and even on the backup components. In regards
Sure. So the confidentiality, integrity, availability. Regulators love seeing encryption, industry standard encryption, where they then, as long as your keys are not compromised, they're happy to suggest to accept that there would be no risk to someone with that data because it would be unintelligible to them. So from a risk management point of view, both on monetary aspects for fines and also for regulatory aspects in terms of having to notify anybody. If you've encrypted your data, your laptops, your mobiles, removable media, etc., it will really reduce your compliance burden. In terms of access control, I think it speaks for itself. For backup, that's part of the availability. If you accidentally lose data, but you can get spun up very quickly again, then you're not going to have an availability breach. And that's one, again, where you said some breaches aren't obvious. An availability aspect can be a breach as well.
So let's throw up our next polling question. Little test to the users or the listeners in there, and the polling question comes up. Are you ready to report a personal data breach within 72 hours? And knowing that the clock starts ticking once you've identified that it's a breach. So we'll let the votes start coming in, see how many people may have already conducted, a tabletop exercise in their organization where you've gone through certain scenarios that can lead to a breach, a compromise of information internally through an employee, compromise of information at a third party with a vendor, as Robert mentioned, because that'll also fall in the mix, or things that impair the ability to get to the data, such as ransomware or other things that may inhibit access to the data and cause harm to an individual, being able to preventing them from being able to facilitate some other responsibilities. So we see just more than half the people have voted. We'll give a few more to come in across the board. While we're doing that, Robert, I'll jump to our questions because there's a bunch coming in. If we save them all for the end, we may not get to them. One that comes across, actually, we want to come back to the questions in regards to receiving information. Question is, if you meet a contact and they hand you a business card during the meeting, is that considered consent when getting
So that's a very, very common question. So actually there I would use legitimate interests. So consent is only one of the 6 grounds, legal bases on which you can process personal data. There's consent, there's necessity for performance of a contract, there's necessity to comply with a legal obligation. There's also necessary for your legitimate interests, as long as your legitimate interests are not overridden by the rights or freedoms of the individual concerned. So where somebody has given you a business card, their reasonable expectation will be that you're going to be using that business card to contact them. Otherwise, they wouldn't have given it to you. So in your legitimate interest balancing test, you would say, my legitimate interest is to market to this person, and actually that is recognized as a legitimate interest in the recitals of the GDPR. The extent of that is debatable, but certainly with someone giving you a business card, I think that's absolutely fine. You would say, so my legitimate interest is to market to this person. They've given me their business card, and in the business circles and in this cultural environment, it's understood the reasonable expectation of that person is that by giving me the business card, I'm going to be contacting them. So it's perfectly fine to use the legitimate interests. Of course, when you do contact people, whether it's B2C or B2B, you need to identify who you are. You need to not hide the fact it's a business communication and marketing communication, and you need to give an easy opt-out methodology.
Okay, great. So we'll pull up those poll responses on the 72 hours. 66% of the people no, 34% yes. So definitely some work needs to be done on those incident response policies. Okay. So we'll go to our last topic before we're going to really delve into more of the questions. And actually quite a few of the questions coming in are on this topic. So we'll try to see if we can get them before going through it. But it's vendor management, due diligence. One of the areas that I mentioned earlier where it's a layer being added into your existing processes. And it's really the controller-processor relation that falls into here. And so, Robert, it's an area that we know for a high percentage of the investment management space is high risk because they leverage so much on third parties and have taken this trust that I've delegated that risk to somebody else, but you're never really delegating the risk. The risk still sits with you, correct?
That's absolutely correct. And with general partner, limited partner, with administrators, etc., there can be quite a few different parties involved in the processing of personal data. The GDPR for the very first time brings into the European law the direct obligation of a processor. Before, the Data Protection Directive was only putting obligations on the controller, and you would back-to-back that to a processor with a contract, but in practice, the clause in the contract was quite small, and I think it was given more lip service in a lot of contracts, unfortunately, than it should have been. What GDPR has done is it's really boosted out that vendor processor obligation. So now the contracts will have a few pages of clauses around the obligations, but as you say, it does not prevent you from being liable. You can't offhand it to somebody else. Anybody in the chain, actually, under the GDPR, can be sued by the data subject, and they can get full recompense from anybody in the chain, and then the people within the chain have to sort it out amongst themselves. And people will be looking at the contracts to say who was liable and who wasn't. And one just on that, when we talk about vendor here, just to clarify, this is about the processing of personal data. So when we're talking about the GDPR, it's focused on those vendors who process personal data for you.
So one of the questions that came up, I'll try to tie it in with two of the questions. One is asked, what is exactly meant by data processing? And then also when should a subcontractor be considered processing personal data? You know, what if they only have incidental access, like conducting an audit?
Yeah.
So definition of data processing?
Yeah. So the definition of data processing is the simple way to say it is absolutely anything to do with data. It goes across the whole data lifecycle. The GDPR definition goes from collection through storage, retrieval, use, transmission, combination, erasure, destruction. It goes through the whole data lifecycle. So if you store information for somebody, you're a processor. If somebody asks you to carry out a trade for these people and put it into this account, and then you're and if it's individuals, then that's personal data. Obviously, if it's a company's account and company name, it wouldn't be personal data.
Yeah. Another question coming in, I think you touched on it a little bit, but what are the minimum contracts required when dealing with processors? People like that word minimum.
Absolutely, absolutely. Well, we do focus on trying to do a very practical, risk-managed, achievable program of compliance. And I think, luckily, as you say, we're lucky the regulators are looking for that as well, looking for no more. And we recommend that because you don't want to create more work for yourself than you need to. But in particular, Article 28 of the GDPR sets out quite a raft of provisions that will need to go into the processor agreement now in terms of, for example, the use of sub-processors. If a processor themselves uses a sub-processor, then they need to let the controller know who they are. The controller has to approve them. You could do it generally or specifically. And you can go and look at Google Cloud, Salesforce, etc. And if you look at they're acting as processors to their customers, they all publish their list of sub-processors. Often, although you're meant to be able to object to the use of a sub-processor, your only real remedy might be to not use that contractor anymore. But that's one aspect. Another aspect we talked about is the notification. So if there's a breach, you want them to be able to respond to you very promptly and let you know what happened on the breach and work with you moving forwards. You can't use a processor unless they guarantee appropriate measures for compliance with the GDPR. So you would want to see that they've got that governance in place themselves. And in terms of responding to data subject rights, you would want them to be able to assist you with identifying recipients of data, where data lives, and helping you with the destruction of data.
Great. So I think I took the right side of the seat. I'm fielding the questions coming in and pushing over to you, Robert, because there's quite a few more coming in. So the next two will try to tie in a little bit. It's really around privacy notices, and we'll put it into two elements of the questions. One, the first person asks, we have several funds that have been in existence for a while. Do we need to reach out to our investors to get in touch with them to tell them what data we hold? And another is in regards to a CRM system. Are they able to continue just sending out the newsletters they have and rely on legitimate interest to continue to marketing? So the first, existing investors in a fund, is there a requirement to reach out and let them know what data we have?
Yep. So it depends on the legal basis on which you're processing that data. So if you're processing the data because it's necessary for a contract, so you've got a contract with an investor, you're going to provide certain information to them, you're going to provide certain services for them, that's why you're processing their data. You do not need to go to them and refresh anything because you're processing under that contract. The big thing, and this is with the CRM bit as well, is if you're processing on consent under GDPR is a lot harder to get than consent under the current Data Protection Directive regime. And the reason for that is you need to tell people when you offer the consent a lot more information under the GDPR than previously. Some rights didn't exist, such as the right to port data, the right to erase data. So you have to tell them in a privacy notice, in order to rely on consent, some more information that you won't have told them before because you didn't have to. So if you're relying, to deal with the CRM one, if you're relying on consent to sign up to newsletters, then you're going to have to refresh those consents when you send it out. One note of caution: don't use the "I'm refreshing consent" as a Trojan horse to be able to just start spamming people. The UK Information Commission has just fined a couple of companies that were, let's say, inadvertently sending emails to people who hadn't previously consented, saying, "Do you want to just consent because we're sending this to you?" And that's not valid. But redoing consent, revalidating consent under GDPR, if you rely on it. If you can't or don't want to do that, then look for another consent, another basis, like, for example, legitimate interests. Now, legitimate interests in terms of marketing, there's a bit of a discussion going on because the GDPR recitals do talk about legitimate interest as being a suitable basis for marketing. The more intrusive the marketing, the more electronic the marketing, the less likely legitimate interest will be applicable. Certainly, the more you start profiling and backing that marketing up with profiling a customer and their use, then you really get starting to lose that basis.
Okay. All right. Well, let's throw some questions back at our listeners. Give you a break for a moment, Robert. So we'll bring up our next poll question, our last poll question, and we do appreciate the participation. I think it's very helpful for those on the line to see where they are amongst their peers. And so the next question is, how far through your GDPR compliance project are you? And as I said it earlier, there are many confessions we've heard. These are anonymized, these responses, so they're not shared across the board. But we'll let people go through and answer these as I'll bring up a few other questions. And there's a theme of questions coming across, Robert, and I'll read them off a few in blurbs and let you know where the theme is. So one is GDPR a requirement for EU, or is it in the US as well? Question coming across is, how does GDPR apply to an investment manager that is based in the US but has investors in the EU? And then also, how does it also tie in with, the onshore investment fund? So I think a lot of the questions are coming around here is, we see it often. We have a fund manager in the U.S., doesn't have a presence in the EU, or maybe they do, but they definitely have investors in the EU. So how do they understand, what's in scope with them?
The territorial scope of EU data protection law has really expanded with the GDPR. So if you are established in the EU, then clearly you have the GDPR applies to you and any personal data that you process, no matter where those individuals are. If you process personal data in the context of the activities of an establishment in the EU, then you are also caught. So, for example, you could be a US fund with a UK subsidiary or sister company, and actually the processing you're doing in the US is in the context of the activities of the establishment in the EU, and that's another way you can be caught. But also if you actually directly sell products or services, including investment, financial products and services, to individuals in the EU, then you would be caught. And if you monitor people in the EU, then you would be caught as well. And the example given there is just even using typical website monitoring tools to see where people are coming from, what they're doing, then that is monitoring people in the EU, and the GDPR would apply. The way it would apply is a bit like a sort of pie chart. So the amount of the data that you have that relates to the individuals in the EU, that's what you've got to comply with GDPR about. Then you have a question of, do I have one level of systems and procedures for dealing with that section of the pie chart and a different level for others?
Okay, great, thank you. So let's pull up these poll results. Why don't we take a peek here? So 33% not started, 26% up to a third of the way through. So half the people, about a third of the way through with 37 days left. 29%, a third to two-thirds, 11%, more than two-thirds, and 1% finished. Congratulations. Though you're never finished. This is a perpetual regulation. There's always continual items, but definitely, where you measure, that 1% person probably, has good sufficient policies and procedures in place, good understanding of what needs to be done, good training, has definitely gotten the agreements in place with their third-party relationships. So thank you very much, everybody, for answering the poll questions. I'm going to jump, Robert, again. More and more questions are continuing to come through. Says, how about if you don't market to individuals in the EU, only companies, but there may be information related to individuals in the EU that are in the subscription documents obtained by the fund administrators as part of the EU entity.
Yeah.
This also ties into somebody else asking earlier about, is a business name and address,
yes,
part of what's in scope.
So, and we dealt with this with a client this week. So, so can you just repeat the question again so I can absolutely give the particular answer, because the client asked a different question.
Sure. So it's basically if they don't market to individuals in the EU, only companies.
Yeah.
So that's doing B2C, just I'm sorry, B2B.
Yeah. So we had this with a slight hybrid with the client. So this is a hot topic because the actual wording of the GDPR is if you offer services or products to data subjects, not to companies, so it's to individuals. So if you do B2B into the EU, then you're not offering products or services to data subjects. The more you start processing individuals' data, though, then you will find that you're going to be subject to the GDPR by way of a processing agreement. You might well start to, once you have if you're looking at sensitive personal data, it's incredibly hard to actually process that. The controller that you're providing the services to will probably be needing to back some stiff penalties onto you. And also, if you're not actually Privacy Shield compliant in the US, for example, an EU business is highly unlikely to use you as a processor, even on a B2B basis with the way that the vendor due diligence is going.
Okay. One other question to come in here. So around legitimate interest, and the question is can we clarify, does sending fact sheets to current clients fall under legitimate interest? And so the fund marketing reports, and I guess we can cover current clients as well as non-clients.
Yeah, so if you again, separating out B2B and B2C, you can basically send anything B2B, and that certainly would be sending a fact sheet to an existing customer is certainly within your legitimate interests. When you're looking at B2C, so the individuals, then which could be a high net worth individual, but most of them tend to work through a legal entity. But if they didn't, you're sending something to a high net worth individual. If they are a customer of yours, there's what's called the soft opt-in, and that's where they have obtained goods or services from you, and you're marketing your same or similar goods or services to them. you can use the soft opt-in. Again, in both of them, you need to give an opt-out opportunity. And again, actually, this is really covered in the e-privacy regs rather than in the GDPR.
Okay, so we're going to have next slide will come up to, and then just two more quick questions. One was around this one. I think I pretty much take, Robert. We store our global HR records in a U.S. data center. What do we have to do to ensure we're compliant? So anywhere you're storing the information, if it's in a data center where you are, it's a data center holding your servers, then you need to make sure the data center is compliant from its needs around protecting the data and information. If it's the data center of a third-party provider, then once again, that's a layer onto your vendor management, your vendor due diligence, and understanding what are they doing for GDPR compliant? Are they able to adhere to all the requirements for GDPR? Next question that came in from somebody around here, which really will lead into our slide after we talk about the no fear of uncertainty, is, what is most important for funds to focus on? And I think we highlighted that before. Really, it's the main key points we said here on the slides, which is the governance, the accountability, policies and procedures tying into the governance, the vendor's third party, being able to report on incident response, training across the board in all those competencies.
I think that's right. I mean, funds tend to have pretty good practices in place. It's often not just written down. And the processing agreements would need to be in place even between group companies or within the corporate structure, which is something that people maybe haven't done before. And you're absolutely right. It is it's that governance structure, having the policies in there. Funds are very good on compliance. They have a very good compliance machinery to get those policies out and training into people. And it is those third parties is where a lot of the risk will be. Looking to see is data encrypted wherever it is to address that as well.
And so in anticipation of several questions that came through, we'll go to our next slide, which is really, how can Cordium help, or how is Cordium working with clients when it comes to GDPR and what we've done with our firms. And whether you're working directly with Cordium or not, this is definitely 3 phases of a project for GDPR compliance that is an approach pretty widely accepted across the industry. And the first, as we mentioned earlier, is getting to know your data, where it lives, breathes, who touches it, but more importantly and specifically producing a data lifecycle recording element. So what we mentioned before, the Article 30 data processing record that the regulator would want to see. And it's a living, breathing document that gets updated as business processes move in the environment. Second is to do a gap analysis. So a gap analysis, as you all know, is pretty important because it identifies gaps that you need to fill. It's also pretty important because it'll identify gaps that you don't need to fill, that are not applicable to your organization. So we know not everyone, or almost no one, wants to overachieve in GDPR. Everybody wants to do what they need to do, but not put themselves in a spot where they're obligated to do more. And then the third phase, which is remediation. Policies, procedures, a lot of showing that strategic proof, and we had a dozen questions come through asking, do we have templates, do we have policies and procedures? So Cordium and AmberGate have worked together through all 3 of these phases, developed the tools to capture the information in phase 1 and phase 2, as well as a policy pack that are Word templated documents that firms can take, modify, adjust, and implement into their current policies or fill complete gaps with new policies to adhere to the strategic proof requirements of GDPR. Robert, your thoughts? I know you're the author of several of these documents and put them together with your almost, well, I won't say how much experience. They show the gray hair on the first slide, but many, many years of experience globally, really working across the globe with data privacy concerns.
Absolutely. I think the policies and procedures that we've put together are, you don't want to create a rod for your own back, because these policies and procedures, you're going to want to be able to audit against them. And people will come in and say, well, have you actually done this? So you don't want something in your policies and procedures that doesn't apply to you. So our approach has always been with the drafting to produce something that is reasonable, that doesn't put stuff in that you don't need to do, that has appropriateness in there, gives guidance and practical examples in the procedures as well to help people make those decisions, take them through those decision trees, take them through those processes on the cybersecurity breach aspect, on the personal data breach aspect, helping them make those decisions, but making them as practical and achievable as possible.
Excellent. Thank you, Robert. Well, I want to thank all our listeners today. I apologize we ran just a little bit over. I will apologize to all those that had questions we could not get to. We'll try to answer them offline. The presentation will be made available to attendees afterwards, so your follow-ups are welcome. We look forward to addressing those. Once again, we thank you for your time today. Appreciate you listening in and look forward to any follow-up support we can provide. Thank you. Thank you, Robert, and thank you, Cordium Marketing Team, for your assistance. Have a great day.